Let me begin my testimony with a word of thanks to the committee for taking this important issue up again, and say to you that I appreciate the opportunity to testify, and I look forward to answering any questions that you may have. At the risk of being accused of being a carpetbagger, I come to you from Texas. And Texas, as you probably know, is the execution capital of the free world. By way of background, you should also know that I'm not a wild-eyed liberal. I was the elected district attorney in the 7th largest city in the United States in the 1980s. I prosecuted death penalty cases, and I compiled a perfect record. All of my cases resulted in the conviction of the defendant, and each of those defendants has been executed by the state of Texas. Finally, the thing I suppose that makes me unique among American prosecutors is that I have acknowledged error and I have assumed responsibility for the execution of a man who may well have been innocent. I'm not bragging when I say these things. I say these things to make a point. I've done more than just talk the talk on this issue. I've walked the walk. I live in the belly of the beast. Nobody ever accused me of being soft on crime when I was district attorney. And I'd like to also make clear that I don't oppose the death penalty on moral grounds. I have great respect for the many fine people who believe that some crimes are so horrible that the only appropriate response from civilized people is execution. But I do differ with those people when it comes to the practical side of the problem, because my experience as a prosecutor tells me that the greatest criminal justice system in the world is simply not competent to decide who may live and who must die. My migration from supporter to opponent of the death penalty began about 15 years ago when I became concerned initially about the number of people when it was becoming clear that we were convicting innocent people as a result of DNA testing. And I undertook at that point a review of my position. I studied a massive review of the death penalty that was carried out at Columbia University and that was released in about the same time, that concluded that the death machine in the United States was collapsing under the weight of its mistakes. Their conclusion was that between 1973 and 1995, 68% of death penalty convictions were reversed on appeal because of serious mistakes. I learned about the same time that the governor of Illinois had commuted the death sentences of more than 160 people based on the enterprising work of a group of undergraduate students at Northwestern University who satisfied him that 13 people who were on death row at that time in Illinois were factually innocent. In June of 2000, because I was still a public figure, even though I'd been out of politics for 15 years, I released a statement that called for a moratorium on executions in Texas. I took the position at that time that I was absolutely confident that none of the people that I had prosecuted had been innocent. About 5 years later, the Houston Chronicle focused on one of my cases. They did an excellent job of investigative reporting that changed my life, frankly, forever. They ran a series of articles above the fold on the first page for 3 days that focused on the Rubin Cantu case. And their conclusion was that Rubin Cantu was probably innocent. I reviewed the case because I didn't remember anything about it at that point, and I concluded that whether Cantu was innocent or not, that I had made a mistake, that my decision to prosecute him for capital murder was a mistake. I acknowledged my error publicly, and I assumed personal responsibility for his execution. When I made the Cantu decisions in 1984, 1985, I was very young. I hadn't tried enough cases at that point to know that eyewitness testimony is often unreliable. A recent study concluded that in the hundreds of cases in which men have been cleared based on DNA testing, that more than 75% of those convictions were the result of mistaken eyewitness testimony. In Cantu, we were dealing with a brutal crime. We had one compelling eyewitness. He was the survivor of the attack. He was shot 9 times, but he became our star witness. We had no physical evidence that connected anyone to the crime, but we did have this compelling witness. I believed him. The jury believed him. Cantu was convicted. Cantu was executed. Everybody forgot about Cantu until 2004, when our star witness recanted his trial testimony. My decision to seek the death penalty based on the testimony of a single compelling eyewitness without any physical evidence supporting Cantu's guilt was a grievous error in judgment. And as much as I'd like to tell you that I'm the only former elected prosecutor in America who finds himself in the position of having to admit an error in judgment that may have led to the execution of an innocent man, I know that there are others. Good prosecutors working hard to do their best every day, make all sorts of judgments in murder cases, but they sometimes make mistakes. And when you add to that the fact that judges, defense lawyers, witnesses also make mistakes, what you end up with is a system that by definition is seriously flawed. As a result, I'm satisfied based on my experience as a prosecutor that the system that we rely on to decide who may live and who must die is broken and can't be fixed. Although in Texas and New Hampshire are obviously very different when it comes to the death penalty, we're alike where it matters most. We're not infallible. In Texas, like New Hampshire, we try our cases to juries, and those juries determine guilt or innocence based on testimony from fact and expert witnesses who may or may not be telling the truth when they testify, and who, even when they tell the truth as they know it, are sometimes simply mistaken. And as is the case in Texas, the criminal justice system in New Hampshire, on its very best day, is driven by decisions that are made by good and decent but imperfect human beings who sometimes get it wrong. And it's against that backdrop, what our states have in common, that I share my experience, which is the perspective of a former district attorney who got it wrong, and who knows firsthand how fundamentally important it is that we keep the promise that our courts will guarantee the protection of the innocent. Although we get it right most of the time in Texas, at least 2 other convictions, both based on what was considered at the time to be expert testimony, but what turned out to be nothing more than junk science, resulted in the execution of at least 1 and probably 2 innocent men. Todd Willingham was convicted of arson and executed based on what everybody recognizes today was nothing more than junk science. As a result, the state of Texas has the distinction, the unfortunate distinction, of having executed a man when there was simply no evidence that a crime had even been committed, because everybody agrees today that the basis for his conviction was nothing more than junk science. We also prosecuted Claude Jones in Texas. His conviction was based on the existence of a single human hair that was found at the crime scene, and that a so-called expert testified belonged to Claude Jones. He was executed before DNA testing was available, but several years after his execution, that hair was DNA tested, and what was determined was that hair had come from the victim of the crime and not from Claude Jones. Finally, what is abundantly clear throughout the country is that negligence and egregious misconduct by players in the system produces appalling miscarriages of justice too often. That's what happened in the 4th of the Texas cases, just Texas cases, that are considered to be innocence cases. Carlos de Luna was similar to Cantu in the sense that questionable eyewitness testimony was relied on, but it was even more egregious because it was later discovered that the prosecutor had engaged in utterly reprehensible conduct and in the process violated the Brady rule. What should make the Rubin Cantu case troubling to this committee is that it can happen anywhere. One of the things that we have in common with New Hampshire is that we consider ourselves to be exceptional in Texas. But the reason why Cantu remains at the center of the innocence debate in America is because he received more than the fair trial that our system promises. That's all that our system promises is a fair trial. Rubin Cantu arguably received a perfect trial. He had a competent defense lawyer, an honorable prosecutor, and a fine judge. And yet 30 years later, very serious questions remain about whether he was innocent or not. The other thing that I want to emphasize is that even when you have a very carefully drawn death penalty statute like you have here in New Hampshire, and even if you have the very best protections that can be devised by human beings, they provide no guarantee that what happened in Texas in the Willingham case, the Jones case, and the Luna case could not also happen in New Hampshire. I believe prosecutors whose very best efforts have produced unfortunate results in capital murder cases have a moral obligation to accept responsibility for their mistakes. They also have a duty to do everything in their power to make sure that their mistakes are not repeated. That's why I'm here today. Some suggest that the price for the only penalty that fits the most serious crimes, the occasional wrongful execution, is not too high. That good intentions, strong procedural safeguards, and a fair trial provide sufficient protection. I disagree. I believe that accepting a system that tries hard but gets it right only most of the time breaks the most fundamental promise that we made to ourselves and each other when we gave the government this awesome power. And that promise was that the protection of the innocents will be guaranteed by our courts. Thank you, and I'm happy to answer any questions that you may have.
Thank you very much for your testimony this afternoon. Are there any questions by the committee? Senator Cataldo.
Thank you, Madam Chair. So thank you very much, by the way, for all you've done. One of the things we're looking at within this bill, it doesn't talk about DNA testing at all. Okay, I remember, I don't know who handed this up, but I remember Craig Bloodsworth spent 9 years, 11 months, and so many days in solitary confinement, and the DNA testing finally made that man not convicted of what he did. Maybe something inside here should be also saying that DNA testing has to be done. That's what I'm looking at.
Well, I think that DNA testing would be enormously useful, but one of the things that we have to recognize is that DNA testing is no panacea. TV has created the impression that DNA testing is the answer to everything. But the fact is, and you'll be told this, or you would be told if you asked by your own law enforcement people, the fact is that DNA evidence is only found at about 10 or 15% of the crime scenes. The vast majority of the crime scenes don't produce any DNA evidence whatsoever. Now, it's a great tool, and anywhere where it can be required, that's a positive step forward. But it's not a solution in all cases.
There's one follow-up on that. I recall this very fairly, by the way. Mr. Ludwig was 9 years later when he did the DNA testing. It wasn't done when he committed the crime, which he didn't commit, but it was done 9 years later, and the DNA testing was proven that he wasn't a guilty person.
And he spent all of those years being called that beast. That beast. All those years. Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
And welcome to New Hampshire.
Thank you.
The chair will call Rabbi